Well, good afternoon, everyone. My name is Whitney Stoll, the DC Post President, and welcome to our April 1st Friday webinar. Thank you for joining us here today and on updates on the Davis-Bacon Act. Joined by me are Bree Beal and Jim D'Amelia, who will be moderating our webinar today and will be monitoring the chat. So we have over 100 registered participants from all over the world here today. So I know you're as excited about this program as we are. Please join me in welcoming our guest presenters, Nicole Atala and Sarah Nash, partners and experts on labor and employment law at Polaro Mazza. This educational presentation will share updates to the Davis-Bacon Act and how these existing wage requirements help fund construction projects like highway and public housing, and dive into the Department of Labor regulations and enforces the DBA for construction contractors. But first, I'd like to welcome you all by introducing you to the first Friday in our series, which is provided to you through SAME's commitment to offering the AEC community effective training, development, and networking programs. The DC Post is helping sustain the future of the profession with these monthly education-focused sessions to deliver topical and relevant content to our industry. So thank you all for joining us as we start our program today. So feel free to use the chat to introduce yourself, share your LinkedIn profile, and add contact information to everyone and throughout the presentation. Ask questions so we can address them during the Q&A portion towards the end. And for those using the WebEx application, you have the option to save the chat at any time. If you go to File, scroll down to Save, and click Save Chat. You may have noticed that we are recording this session. We will post the webinar on our YouTube channel later on this month and send you the slides and your PDH certificate as soon as the webinar ends. So we're glad we can offer you an hour of education and virtual networking regardless of where you're attending from today. Let's start with a moment of silence to remember our active duty military, first responders, and all who need our care and thoughts throughout the world right now. Thank you. And please join me for the Pledge of Allegiance. So I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. We'd like to take a moment to thank our DC Post annual Platinum and First Friday sponsor, Fox Rothschild. We truly appreciate your support, and we could not have put on our event without you, and we're grateful for your outstanding sponsorship. Your support helps us meet our society's goals, including providing excellent content to our members, industry and government engagement, building resilient communities, and connecting our future leaders through our student and young member groups, enriching the STEM pipeline, and preparing a military veteran for life after service. If you're not already a DC Post sponsor and would like to support our post with annual sponsorship, we'd love to add you to your name to this slide and future programs, as well as events this year. Annual Platinum sponsors and First Friday sponsors help support this webinar with free registration for members and full-time students. Please visit our website for more information about sponsorship levels and how you can give back to your community through your DC Post sponsorship. And now it's time for the main program. Please note this program will provide one professional development hour from the DC Post. Look for an email with the subject line document delivery from SAME DC and Eventbrite with a copy of our program slides, your PDH certificate, and a list of opt-in attendees who pre-registered for this session. We are recording this webinar and we'll post a video on our website later on. I'm not going to read to you the learning objectives on this slide since most of you already saw the same objectives when you registered. Instead, I'm going to introduce to you our featured speakers in just a moment. While I do the introductions, and if you haven't done so already, please use the chat to introduce yourself, share contact information, and where you're from. This is your webinar series to help you learn about the special topic, as well as help you expand your business network during the program. Share comments, ask questions to the presenters. If there's a particular slide you want to talk about, please share that detail in your chat question. We'll be sure to answer the questions at the end of the program. Don't forget to save the chat before you exit the webinar. Now going on to present the speakers. So Nicole Altala is a partner at Polero Mazza and specializes in employment law, offering guidance on Title VII, ADA, ADEA, FLSA, FMLA, wrong termination, and reduction in force. She also advises on general business matters such as employment compensation, benefit arrangements, and contractual agreements. With extensive experience in government contracting, compliance, and tribal employment issues, she navigates the FAR Part 22, Davis-Bacon Act, Service Contract Act, and Equal Employment Opportunities. Wow. Thank you, Nicole. And also,
Thank you, Whitney.
yeah, no, I was going through all the acronyms.
It's a mouthful. So.
It is.
An alphabet soup.
And then we also Sarah Nash, and Sarah chairs the Labor and Employment Group at Polero Mazza and focuses on the Fair Labor Standards Act, National Labor Relations Act, and anti-discrimination law. She counsels both government contractors and commercial businesses. So Sarah's practice covers terminations, labor relations, employment agreements, wage and hour issues, and government contracting compliance, including prevailing wage laws and equal employment opportunity requirements. So Nicole and Sarah, thank you very much for joining us here today. I'm going to turn the presentation over to you.
Thanks, Whitney, and thanks
Thank you,
SAME, for having us. Sarah's going to pop up our slides here.
They should be coming. Oh, spoke too soon. I had my whole system set up and then let's see.
Oh, well, Sarah's doing that. She can give me the high sign if she's having trouble. But today we wanted to talk about all of the updates to the Davis-Bacon Act. So it's not exactly a 101. So if you need basic Davis-Bacon Act, like I'm not really comfortable with the Davis-Bacon Act yet, let us know, give us a call. We have some resources on our website that can provide that for you. But what we really want to talk about today is, how you can use the new revised Davis-Bacon Act, the reshaped labor landscape to advantage you. I think Whitney covered all of our bios, but Polero Mazza is a business law firm. We're a strategic partner to government contractors. Primarily, we do have clients who are also commercial businesses. We're going to touch a little bit on how the Davis-Bacon Act can affect folks doing work in the commercial sector as well today. But we are really, partners with our clients in a broad range of subject matters, and really happy to be able to do some community outreach and taking kind of what we know and helping with the First Friday program for SAME. So what do we really want to talk about today? We're going to very briefly say what this thing is, just to set the stage more than anything. We're going to talk about some of the principal changes in the Davis-Bacon Act regulations. This is one of the only overhauls in, I think, 20 or more years on the Davis-Bacon Act front. So this is a big change, and we want to talk about how the regulations really will impact you day to day, whether you are in government and trying to make sure these things are procured correctly, or whether you are a contractor. And then we'll go over some key takeaways and why you should care about some things that maybe don't seem that relevant to you. So the Davis-Bacon, Sarah, you go ahead. Sorry, I'm stepping on Sarah's toes already. We're just starting.
Everybody loves talking about the DBA. That's just like a fight to who gets which slide. So Davis-Bacon Act, Nicole mentioned, it's been a prevailing wage law that applies to construction for a long time. It was first enacted in the 1930s. The last time we saw really big changes was during the Reagan administration. So this is a pretty big lift. Of course, DOL is saying it's not a big deal. It's more business as usual, but that's just their marketing strategy there. So the DBA is just, what we've been talking about. It's a federal prevailing wage statute that sets the prevailing wage and fringe benefits for employees who are working in the construction industry. And it requires very specific prevailing wages, and fringe for labor and mechanics. Those are individuals who are going to, working in those construction industry fields in those labor categories that you pay them a certain prevailing wage and fringe. Pretty straightforward, right? And it used to be that we would say, don't worry about evaluating whether this applies to your contract. You just need to see the specific FAR clause and the specific wage determination. It will tell you everything you know. The new rule kind of flips that on its head a little bit. Nicole's going to talk about that in a minute. But ultimately, it's applying to those construction workers that you have working on your sites. And it's specific to construction, alteration, or repair of public buildings or public works. Seems straightforward. There's a little bit of ambiguity in certain contracts, whether what something is repair or maintenance. There's a lot of case law on this topic. We're going to talk about it a little bit, but generally that is the world that we're operating in. There are also Davis-Bacon related acts. There's about 70 of them that have been legislated over the years that are similar to the Davis-Bacon Act, only they apply to slightly different circumstances. So you might, if you work in DBRA world, help fund construction projects like highways, public housing. There's a list of 70 of them on the DOL's website. Both of the DBA and the DBRAs are regulated and enforced by the U.S. Department of Labor's Wage and Hour Division. This rule has revised both of these criteria of contracts. There's also recently, if you guys were paying attention to the news, an Inflation Reduction Act that was passed, big legislation and climate change. And that legislation specifically included basically tax benefits that you are entitled to if you comply with Davis-Bacon requirements. So if you're paying your workforce a prevailing wage, if you're satisfying those obligations, you are entitled to those tax benefits. Of course, in the infinite wisdom of the way our system works, it's not DOL that's enforcing the IRA, it is the IRS, and they have never done this before. So there's going to be a lot of questions. There are already some IRS regulations coming out about this new legislation, but if you're in the construction world and you're thinking about getting into the IRA sort of tax benefits, there's a whole world of opportunity there. Nicole, I know that you know a lot about this law. Is there anything else you wanted to add?
I mean, the primary place we're seeing them right now is on large energy projects, right? Because they have to cover under the type of projects that the Biden administration is trying to incentivize. So we're already starting to see those deals come together with multiple stakeholders and trying to figure out how exactly to confirm compliance with the Davis-Bacon Act requirements in a landscape that's not used to seeing Davis-Bacon Act requirements. So again, if you are familiar with the Davis-Bacon Act, there could be some opportunity here for you in that sector, especially because you're familiar with it and might pose less of a risk than perhaps some other contractors.
Absolutely. So that's the framework that we're getting into. Nicole mentioned we're not doing a 101. If you have questions about DBA more generally, we're happy to address them either in the question session or offline, but this is really a focus on what changes were implemented last October when this new rule went into place. So we're going to get into some of those details now and over the next 45 minutes or so.
All right, so this is one of my favorite subjects in the changes because I think it's going to pose some of the most challenging components of legislation or regulation, I should say, not legislation, to maneuver for contractors that are used to a world where you look in your contract and your contract controls, right? So that's what we always used to tell clients. Look in your contract controls. Look in your contract controls. We can no longer say that. Should also be clear that the FAR clauses have yet to be updated here, so we do not have new federal acquisition regulations. They are now anticipated to roll out in May 2024, so we'll see how the FAR Council has tackled the regulations from a federal acquisition regulation standpoint. But right now, because of this whole concept of effective by operation of law and the fact that the regulations are effective, you should assume that the regulations apply now to your contracts, even without a federal acquisition regulation. And what do I mean, and what are we talking about? We're talking about by operation of law. Well, we're talking about an instance where the Davis-Bacon Act bar clauses are inadvertently omitted from your contract, or where a wage determination is incorrect or inadvertently missing from your contract. And so when you look at this thing, there's not maybe an obvious path to identifying that this is a Davis-Bacon contract. And some of you might be saying, well, duh, it's a, I'm getting federal funding. There's federal funding on this project, and every project we work on is Davis-Bacon, so we assume it's Davis-Bacon, and that might be your situation. But there are a number of contractors who are in, for example, the maintenance repair, working on large MATOC contracts that have the SCA and the DBA incorporated in them, right? And trying to figure out what's maintenance and repair. And we used to say, well, if there's no Davis-Bacon Act wage determination in that contract, don't worry about it, pay the SCA because the DBA doesn't apply. You can't do that anymore. You've got to self-identify that there is Davis-Bacon work on this contract and go out and get a wage determination. That's what you got to do in order to be compliant. So DOL can also institute enforcement actions before the clauses are incorporated. This also creates some interesting issues about price adjustments and changes clauses, right? So if the regulations are implemented by operation of law, what we used to do in the pre-February,
good old days.
It's not February, is it? I'm conflating non-displacement with this, but in the good old days, it's October, right? What was the date, Sarah? Do you know?
October 23rd, yep.
Yeah. Apologies. Non-displacement rules that apply to SCA wouldn't affect February 12th, and this was October. We still don't have a FAR clause. So what it really means in the price adjustment or changes clause world is if we had a DOL investigation and the Davis-Bacon Act clauses were not in the contract, we would say, hey, government, it's a change to our contract. DOL is requiring incorporation of the Davis-Bacon Act. We'd have DOL go back to the agency, fix it, and then we would request a price adjustment under the changes clause. Now that it applies by operation of law, I think there will be some interesting questions about how contracts get updated to include the right stuff, right? The contract clauses might be a little bit easier of a lift, but the wage determinations, if there's an incorrect wage determination that is applied to a contract somehow, you need to say something very early because, we're going to have to kind of maneuver how that change works if a contracting officer incorporates a wage determination that's incorrect. Even more scary, I think, is the proposition that a contractor might think that a wage determination is incorrect. And so it goes out and it says, I think there's an appropriate wage determination that should be used. There's a disagreement between the contracting office and the contractor. The contractor implements what it thinks is correct because it's concerned about this by operation of law issue. But now there's a dispute in the contract that the agency and the contractor have to figure out a way to resolve. And that also could have price implications. So I think this is going to be one of the bigger issues. It's a big change. It's a change that the Department of Labor has wanted to see for quite some time. They did not like relying on agencies or having to go back to an agency to get it fixed. Now they can deal primarily just with a contractor. If you have Service Contract Act contracts, I think this is also on the SCA wish list. Has not changed, though, on the SCA side of the house. On the SCA side of the house, we still have to have the right stuff in the contract, at least until they get around to changing those regulations too. But we are definitely seeing more of a push to automatic implementation, more responsibility on contractors and away from contracting officials.
Sure. And I mean, one of the big considerations here is price adjustments, right? So Nicole, you mentioned just because they haven't included the right wage determination or the right FAR clause doesn't mean the agencies are off the hook. but there's still plenty of room for disagreement. So where you're going to run into some really kind of gnarly spaces is where maybe DOL, and this happens all the time, right? DOL disagrees with the agency over whether the Davis-Bacon Act should be applying to this kind of work. DOL disagrees over which wage determination should have been incorporated. So there's just a lot of room for gray area. We're hoping that the FAR clauses will clear some of that up, but in our experience, they don't always add much more. So we'll see. We'll see. When they were originally supposed to come out back in December, that was kicked. It's been kicked again. So we're just keeping an eye out. There have also been some pretty big definitional changes to the new rule. Things that were not previously defined have been defined. This was really, I think, DOL's wish list as they go over their investigations over the last few years. They're saying, what are some things that really mucked up the process that would have been nice to have on our side? And so for the most part, they've stacked the deck a little bit. One of the big changes is going to be the definition of the site of work. It's been expanded to include secondary construction sites, and that's not new, right? There have always been secondary construction sites, and it's always been where a significant portion of the work is constructed there. The sort of change, though, is that there has to be a portion of the site dedicated to the project for a specific period of time. And I'll get a little bit more into the details on that, but whereas previously a site had to be specifically created for Davis-Bacon work, that's no longer the case. It just has to be dedicated or in large part to that work. Another big change that I'm guessing going to start to see the repercussions of is the definition of the prime contractor. DOL in the regs expanded this definition to make clear that it applies not just to, the company, but to any controlling shareholders or members, any joint venture members, and anyone who has been delegated generally responsibility for overseeing all or almost all of the construction anticipated by the prime contract. In and of itself, not the biggest deal in the world, but there are some sort of snowballs that come from this change. Because of this new definition, and because of the way that DOL is applying cross-withholding, there is a new world of enforcement mechanisms that weren't necessarily present before. So generally, if a contractor has not been compliant with the Davis-Bacon Act, DOL has in their toolbox some mechanisms to encourage enforcement of DBA. One of those big mechanisms is withholding, right? You didn't pay your employees the prevailing wages that should have been paid. Therefore, we're going to reach out to the agency and withhold from your contract so that the agency stops paying you and starts paying DOL so we can start paying these employees eventually after the process. Cross withholding, you all may be familiar, is this idea that DOL might not necessarily go after just the contract that's the subject of the DBA work, but a separate contract that you're working on. So you might have contracts with the VA, with DOE, with Department of Ed. All of a sudden, all of those contracts can be cross-withheld if DOL has identified a violation. Now, because of this broader definition of prime contractor, where it applies to not just the company itself, but it applies to any controlling shareholders, it applies to joint ventures, there's a much larger web of cross-withholding that the agency can go to. So not just the agencies that have the direct contracts with the prime contractor, but all of those other entities as well. So it just makes non-compliance that much costlier to the extent that you have maybe you're just a member of a joint venture. You've been doing everything right, but your partner has not necessarily checked all the right boxes. All of a sudden, that could really have a big repercussion on your other work. So it's just, you want to be careful about who you're going into business with. This has always been the case, but just a little bit more of an incentive now with the new change. Some other additional definition changes, construction, prosecution, completion, or repair. These have all been expanded to include demolition and removal work. is basically the way that the case law had played out already, but with the new, it's explicit in the new rule that if there is subsequent construction work that's DBA, that's planned or contemplated, then the demolition or removal is also going to be DBA work. So it's just making clear that certain construction, certain demolition is covered within that definition. There's also some broader definitions of construction and of buildings or work, just to make clear that it applies to sort of those more modern construction. So if you have solar energy, things like of that nature, it is expanded within the definition. It makes sense. Building or work is also going to include wind turbines, broadband, internet, things of that nature, you know, just bringing us into the 21st century. And then it's also been expanded to include construction activity that's only affecting a portion of a building or work. So for example, if you've got a room within a building, if you've got a large piece of the, like a module, that stuff is going to be considered. Just additional ways that DOL has been looking to expand the definition when DBA applies. And remember, there's a couple consequences here, right? As we're expanding the definition of building or work, as we're expanding the definition of construction, we also have this operation of law that's been beefed up. So now it's just that much easier to walk into DBA work without necessarily knowing that that's what you're getting into. We often see this in installation projects where Nicole mentioned this, you've got a lot of SCA maintenance, but then you've also maybe got some DBA work that might apply. And so those sort of questions about what's SCA, what's DBA, are going to be a lot more important that you get the right answer. So we'll see how that rolls out in the coming months. One of the big changes has been to the definition of a material supplier. Generally, material suppliers are not considered construction contractors or subcontractors, so they are excluded from the DBA requirements. There are some exceptions, though, where a material supplier, someone who's bringing materials in, does not satisfy the material supplier exception and therefore is covered as a contractor. And so there are 3 criteria that are required in order to meet sort of the definition of a material supplier. One is going to be work on the contract must be limited to the supply of materials, articles, supplies, etc., which may include pickup in addition to, but not exclusive of, delivery, and which may also include activities incidental to that delivery. So drop off, waiting time, stuff like that. Let's unpack that a little bit. What that means is if you are exclusively delivering, if you are exclusively picking up materials, you're not going to qualify for the material exemption. Similarly, if you are doing any construction activities outside of that delivery, drop off, and waiting time, you're going to suddenly be consumed within the rule. So just important. This DOL, again, they're saying is not a big change. This is sort of how the rules and the case law has evolved over the last few years. But there used to be sort of a percentage. If you were doing 20% of the work, then you're a material supplier. If you get more than that, then you don't qualify. They've gotten rid of that prior rule. Now these new criteria apply, much more straight edge. Similarly, the facility must have been established for the material supplier, must have been established before the solicitation. Or if it was established afterwards, it can't be exclusively dedicated to the performance of a covered contract. Just shows that if you created this facility, this material supplier's facility specifically for the contract, it's more likely you're going to be a material supplier, or less likely you're going to satisfy the exemption of material supplier. And then lastly, the facility manufacturing the materials may not be located on the primary or secondary construction site. That's a pretty straightforward rule. You can't be on one of those sites if you're going to satisfy the material supplier exemption. Now this brings us to the return to the 3-step method. This is it's a pretty big change, but ultimately probably not that impactful on the fact that it's likely going to increase wage rates over the next few months. A wage is now prevailing in the locality if the wage is paid to at least 50% or more of the workers, or if there is no wage that is paid to 50% or more of the workers, then the wage at which 30% of the workers are paid. And then
sounds like a math problem, Sarah.
it is. It's sort of like how many, if a man and a half can dig a ditch and a half in an hour and a half, how many hours does it take? Yeah, it used to be 2 steps, right? Which was a little bit more straightforward. So if a wage is paid to 50% or more workers, that's the prevailing wage. Otherwise, then you use a weighted average. What DOL has done is they've added the second step where they're looking at that 30% of workers are paid. You know, there's been this question raised, well, that's not prevailing wage, right? If it's only 30% or 31% of the workers are being paid that wage, how is it prevailing? DOL has a long history of taking liberties with, you know, prevailing or what it means to have primarily be engaged in. And so this is just, and this is also not new. This is what the prior rule was back in the 1980s. DOL has just returned to its long lost love affair with the 3-step method. What this means is that we are more likely to see wage increases because you have to remember that a big part of construction work, a big part of Davis-Bacon work is unionized workforce. In fact, if you look at your wage determinations, you can see pretty much every instance where union wages have informed the prevailing wage rate. You'll have the sort of acronym of the union, maybe the local numbers cited there. So because unions play such a large role in determining the prevailing wage, where you are finding more ways to get majority pieces of the work, so 30%, for example, it's more likely to be done by union work. And whenever it's more likely to be done by union work, it's more likely to be higher because you've got, you know, you've got collective bargaining representatives who have negotiated higher rates. It's just, you know, a known fact. Union work is a higher paid wage rate. And so over the next few months, we are expecting to see these prevailing wage rates increasing. Ultimately, not the hugest, you know, difference, because ultimately you just incorporate that into the bid. But there are some important considerations. One, as federal construction work gets more expensive, it's likely that other work will also get more expensive, right? Because why would an employee want to work minimum wage on a commercial construction project if they have the option to earn prevailing wage, which is maybe $10, $20, $30 more on a Davis-Bacon Act project? Just something to consider about the market. Additionally, because of the operation of law considerations, now it's also a lot more costly to get this stuff wrong. So if you do have a back wage investigation and it turns out that you've been paying these workers incorrectly, the dollar amount on that back wage, WH56, could be a lot higher. So just something to consider as you're evaluating these things. And while the government is supposed to pay for the increase due to their failure to leave out, their failure to include a wage determination, we all know that that doesn't happen automatically, right? And so there are several months now where contractors might be waiting for those payments to come through. Meanwhile, DOL is not the most patient in the world, and so it can be just a cash flow issue. And I think that pretty much covers the 3-step method. So as we work towards this 30%, we're going to see more unionized rates versus more average weighted averages.
All right, so in a couple of other changes to wage determination rates that you just want to pay attention to. And this first one, I actually don't mind all that much. I think this will hopefully be helpful to a few folks. But if you recall, in the past, DOL didn't really automatically issue and update wage determination rates. So now they intend to use the Bureau of Labor Statistic data to automatically update those rates for non-CBA wage determinations. So if you have a wage determination that's not based on collective bargaining agreement, they will update that using BLA statistics. it's probably a very similar process to what they do with SCA wage determinations. They don't take, you can have CBA wage determinations, but the general wage determinations are updated using BLS data. They won't do that any more often than every 3 years. And then, we can expect some court challenges there, depending on how this actually shakes out, because these updated wage determinations that are automatically updated could face some court challenges. There's also more discretion for DOL to adopt state or local prevailing wage rates under the Little Davis-Bacon Acts. So in the past, they could only adopt those state or prevailing wage rates with the same methodology. And so now they're taking a little bit more liberty to just adopting those state and local wages, which hopefully will streamline the process a little bit, but again, could have impacts on discretion for increasing those wage rates more quickly than they otherwise might. One of the bigger areas of concern is this idea that they're not going to segregate data for rural and urban areas. Those will kind of be combined in one. So they used to have kind of like a wage determination for rural areas and wage determinations for cities. Those are going to be combined. We expect that means that the rural areas will benefit from the higher wage rates in urban areas. I think from DOL's perspective, that makes some sense because these areas are quickly becoming a little bit harder to delineate. Where does an urban area end and rural area begin? And that can create some challenges. So again, this all falls in line with DOL's, efforts to try to get the highest wage rates possible, I think, for employees. And that is consistent with the changes that have been made to wage determinations. I think the conformance process also falls in line with those changes to the WD process. So if you didn't have an appropriate classification on a wage determination, you would submit a conformance request in order to get that classification added. So if you were working on a big base, let's just say a military base, and you needed to do some highway work, but that wasn't on the wage determination rate, then you would go out and try to get those classifications added to the wage determination. And you would do that through these conformances. Now what they're going to do is take commonly conformed rates in a wage determination. So classifications that they're commonly asked to provide conformances for, and they are going to basically, make them regular rates. So they will list those commonly conformed rates in the wage determination, even if they didn't have enough data in their surveys to determine a prevailing wage rate. They're just going to publish them. I am cautiously optimistic that this will ultimately help contractors get a rate. So one of the problems is contractors often don't want to go to get those conformances. So we're kind of guessing and maneuvering, and that can be challenging. So I'm hopeful that when they take these commonly conformed rates and they publish them on wage determinations, that this will actually streamline the process. Again, cautiously optimistic here, but I'm hoping that is actually a positive development.
Yeah, if anyone out there has tried to do the conformance process previously, at least for me, it's not my favorite activity. It involves math again, but this should hopefully cut out some of that additional and some of the uncertainty, right? Because you never know if your conformance is going to get accepted, but now we have the added benefit of having it already explicitly stated in the wage determination that was hopefully included in your contract. There have been also some changes to the related acts debarment process. We mentioned earlier that there were, DBA versus DBRA. So under the DBA, there's previously a disregard of obligations, or currently too. There's a disregard of obligations. If you disregard your obligations, there's debarment on the table. DBRA previously had a heightened standard. It was this aggravated or willful violation standard. That is no longer the case. Now DOL, out of the goodness of their hearts, has given everyone an equal standard across both DBA and DBRA. They've made life easier, is their position, and it's now consistently disregard of obligations. Additionally, the 3-year debarment is now mandatory for Davis-Bacon related acts. Again, consistency is just the utmost priority, and there's no ability to apply for early removal. I mean, I guess if you're learning this stuff, it is a little bit easier. If you're performing DBRA work, the standard just got a little bit more difficult if you're looking at debarment.
And let's be honest, they're always going to throw a debarment in your face in order to force compliance, right? Like that's one of the sticks that they have available, and it's one of the scariest sticks. And it encourages settlement quickly. When you get into the litigation process, even when you disagree, there's always this threat of debarment that is often scarier than some of the compliance standards when it goes into a complaint. It's not that scary at the investigation stage, at least to folks that deal with these investigations frequently. We hear it all the time. And by the way, we could debar you. And I'm like, yeah, let's talk later. But when you get to an actual complaint, you're litigating it, you're spending money on this stuff, that it can get a little scarier. And again, they've noticed they did not move everybody to the aggravated or willful violations. They moved everybody to disregarded obligations, right? So they're trying to make it a little bit easier to use that stick.
And remember, DOL doesn't necessarily have much more information about how these new rules are going to work. I mean, I'm sure that they have a plan for how they're going to roll it out, but it should not be a faux pas to question the investigator. We talked to a lot of investigators who are learning this stuff and don't necessarily know the industry all the time. And so you should feel comfortable pushing back, but you want to make sure that you understand what the obligations are first before you get too far down the road and DOL has issued a complaint against you, because that gets messy.
Other notable changes, just before we wrap up and get to questions, you have additional record keeping obligations, so make sure you're keeping records for a period of 3 years. One of the biggest changes, I think, is this anti-retaliation clause that allows the Department of Labor to have make-whole remedies for someone who they believe has been retaliated against for either complaining about Davis-Bacon Act violations or participating in an investigation. Keep in mind, anti-retaliation is not in the statute at all. So this is a significant reach, I think, for the Department of Labor, but you can bet your bottom dollar that they're going to enforce it. It's in all of their new regulations. They want to make sure that they have that ability to hold contractors to account for what they believe is retaliation for participating in an investigation or complaining. The clarification of prime contractor liability for lower tier subcontractor violations. We've always known that to be the case, right? That prime contractors are ultimately on the hook for the liabilities of their subs. They're, doubling down and making sure that prime contractors understand that, which will, in DOL's eyes, hopefully lead to more sub-compliance, because we see a lot of issues at the subcontractor level. A good reason to vet subcontractors, right? Or at least provide some resources so we know that they're doing what they need to be doing. And it also codifies guidance regarding the annualization of administrative fees that you can credit toward fringe benefit obligations. These fees that third parties are charging contractors to administer benefits are really under close scrutiny from the Department of Labor. Again, this is one of those things where the Department of Labor says we've always taken this position. Now we're just writing it down on paper. So you want to be careful and take a look at your agreements with third-party benefit administrative companies and make sure that you're comfortable with the fees that they're charging and you're comfortable with annualization. I can't ever say that word. Okay.
Great. So that just brings us to our wrap up, and I've seen a lot of questions come in. Of course, they've gone into the ether. I know where they are. I'm sharing my screen, so I can't see any of them. So sorry we couldn't get to them while we're talking, but we'll definitely address them in our question period afterwards. But just like brief takeaways, things, if you walk away from today thinking of anything, these are things you want to have top of mind. Be ready for increasing prevail weights, especially in certain localities. Rural localities are probably going to jump up a little bit faster. But if you're working in a place that has, 30% union rates, those rates are going to start taking over soon. Another consideration is those contractor responsibilities that are sort of ramped up. So you got to make sure that you know whether a project is subject to the DBA or the DBRA requirements, because if you're not paying attention to this, if you're not asking the right questions at the beginning of the project, there could be some unpleasant surprises that pop up. And just because the agency has left something out, that's no longer a defense. You have an affirmative obligation to be evaluating your contracts for whether DBA applies or not, and whether which wage determination should apply. So it just got a lot more, that responsibility. It used to be the contracting officers. Now it's the contractors. So maybe contracting officers have a little bit of a lighter expectation on their plate. And then also withholding back pay considerations are not dependent on a contract adjustment. Just keep that in mind. There's still rules in the regulations that require that the agency pay back wages for, a miscontract, like something that was left out, but it's not as clean cut as it used to be. Nicole, I'll let you handle the last couple.
Yeah, so again, remember those record keeping obligations, remember those anti-retaliation provisions. If you have a Department of Labor audit and then you want to fire a person who just participated in an interview, let's make darn sure we have good records of why we terminated that individual or had a foreman walk them off, right? And, we've got this uphill battle with the new debarment standards that we just talked about. So again, make sure you familiarize yourself with these new obligations to ensure compliance. Ask questions, phone a friend, phone a colleague, right? Because we're all kind of in this new world. So, and with that, we can do, I think, some Q&A.
Great.
Well, that was great. No, I appreciate the overview and definitely very informative. We do have questions coming in, but if anybody else has questions, please feel free to continue to add them to the chat. But let's dive right into it because I'm sure some of these require some explanation. But we have one on the Inflation Reduction Act. So on the IRA is based on compliance for DBA wage rates for tax savings. Does it only apply to the prime contractors, or would it also apply to the subcontractors or trade partners too?
The way I understand it, the prime contractor needs to be able to take advantage of it, right? So if you're a sub and you're working with a prime on a project, you want to make sure that the prime is on board with like your compliance if they don't plan on complying, right? So you still have to work, because your subcontract is just like basically you're all working on a commercial contract, right? So presumably you should be able to take credit for pieces of it if you are Davis-Bacon Act compliant. But what I'm advising clients is to really work with those, general contractors, the prime contractors in that situation, to make sure that everything is in line from a taxation perspective. And from a legal perspective, this is really multidisciplinary. So we're working with tax lawyers, energy lawyers, labor and employment lawyers. We're all kind of working together to make sure that businesses are primed to take advantage of these tax credits. And so, while I believe that the regulations would allow a sub to take credit, I highly recommend you work with your prime to make sure that everyone is in line to take advantage of those credits.
Great, thank you. Elaine from Whiting Turner asks, how does the new definition of prime contractor apply to owners' reps?
Yeah, so and Sarah can chime in here too, but I do not believe the way the regulations are written that lawyers have to be concerned, like representatives that are not the prime contractor or a joint venturer would be on the hook personally, right? So I'm assuming given where Elaine works, that is one of the concerns.
I mean, I'm sure DOL is kicking themselves for not thinking about this because, yeah, so far, I don't think there are any consequences for representatives. Of course, I'm thinking of California right now. They've been passing a lot or trying to pass a lot of legislation, but otherwise, generally in the government contracting space, we're not seeing a lot of that.
Yeah, and it really, I think, is positioned to get to those joint venture partners and to be able to cross withhold on their contracts, to get to those. We've always known that owners and have some liability there, but I really think this is positioning to get as more and more companies use joint venturing as a bidding strategy, as a win strategy. I really think that's what they're trying to get to. You have a joint venture partner that's non-compliant. Now I can get to your partner and their owners, right? Because everybody, so it gives me more avenues to recover if I can't find one party or I can't recover from one party.
Okay, great. So we have one from Shirley. Has DOL updated the AAM 130 and 131 to include which construction types all these new additions belong to now? The AAM includes a long list of examples, but not sure if they've updated it.
I don't think they have.
Yeah. And usually what they do with those, like they might provide an update, but you always have to very closely watch those dates because they get really old. And so one thing we're always trying to keep in mind is when was that thing published and was there an amendment to the regulations after it was published? But I don't think there's been anything new.
Okay. We have one from SR, and this is concerning site work. This can have a major impact on off-site prefabrication facilities used to assemble modular parts of the work. What is the specific time period or period of time that's mentioned? An example of a potential problem is an electrical sub dedicates its off-site prefab plant that does this across all their contracts, dedicates their plant for 4 months for a specific DBA contract work. Does this sub now have to pay DBA wages for 4 months, even though the prefab site is used for other work at other times of the year?
It does specify the period of time, which indicates that it's only for the time where it's used specifically for that project.
But it doesn't say like 6 months, right?
Yeah.
It's intended to be the period of time that, like Sarah said, for that project. So I think the way I read this is if I basically take over my prefab facility in order to prefab for a specific project for a 4-month period, it's just going to be that 4-month period for that project, right, Sarah? It's not going to be like, it's not going to extend beyond that.
Correct.
Okay, great. And one more question is there any litigation pending to challenge these new rules?
Yes, there have been 2 lawsuits that have been filed. Guess in which state? Texas. I love to file Texas.
Always Texas.
You got a labor or employment challenge that you're itching, it's always going to start off in Texas. We haven't gotten far in those cases though. They were filed by American builders and
several states, I believe, too, joined.
Yeah, so we'll see. I think they have some viable challenges to the way DOL has rolled this out, but DOL does have a lot of discretion. So we'll see what comes out of those. So yeah, don't all hope is not lost. This stuff could be going away, but it's probably going to be a minute before we know for sure.
And I actually think what will be play into this a lot is the attack on kind of the authority of the executive and the authority of agencies to promulgate regulation. You've seen a lot of cases, even outside of this context, the deference, like there's a case pending at the Supreme Court regarding the deference that has to be paid to certain agency regulation. and where that authority should really lie and how far agencies can go. If you are into legal wonky stuff, even though it might not apply specifically to construction, those are cases to really watch because they're going to really impact how agencies roll out regulation and the authority of the executive. And in light of how fast Congress is moving these days, could be pretty important.
Well, great. Well, I appreciate that breakdown. If anybody has any last questions, I know Nicole and Sarah will stay for a couple minutes afterwards, but we're going to wrap up our presentation. And thank you again, Nicole and Sarah, for your expertise in this area. And thank you, everyone, for participating in today's session. We definitely appreciate your time here today. Definitely been very informative. And we had a lot of interest from our participants here today. So again, thank you very much. But before we wrap up our program here today, I'd like to share with you all some upcoming events that we have planned. So please mark your calendar for some of our upcoming local post events, as well as upcoming national events. We are committed to bringing you some more content and fun events in 2024. Our next First Friday series will be on Friday, May 3rd. As always, all registered participants will earn one PDH certificate. We are bringing Judy Brandt, who's going to be share with us simplified acquisition, Simply Wow. And it's all about how you can leverage simplified acquisition to supplement your architecture, engineering, and construction opportunities for direct awards from government agencies. So registration is open now. And are you interested in sharing your knowledge on current education topics for our First Friday series with our members? We are accepting presentation applications for summer topics. Please visit our website and submit your topic today. Sponsorships are also available to help support this popular program. You may have seen our upcoming U.S. Capitol building tour and happy hour announced for next week, and we've already sold out for this very popular event. Look for more building tours from the DC Post this year, as well as more networking and social events so we can grow our AUC community together here in the Washington, D.C. metro area. Join us on April 24th for our upcoming DC and Nova Post 16th annual Small Business Conference. This premier one-day conference is just 3 weeks away, and we're returning to the Capitol turnaround near the DC Navy Yard right here in Washington, D.C. We have a great lineup of government agencies that share the latest opportunities and challenges to help fill your government GovCon pipeline. There'll be lots of opportunities to build your network and focus on small business teaming at this event held right here on Wednesday, April 24th. Sponsorship opportunities are still available, so please register today. We've been working very hard on this, so it's going to be a great event. So please, we look forward to seeing you at the event. So make sure you mark your calendar for upcoming DC Post opportunities. Our summer campers are all set. The DC Post provides scholarships to 10 high school students to join our week-long STEM camps around the country. Now is your chance to support our future leaders by becoming a mentor or staff at one of these camps. Applications are due April 15th. Our DC Post scholarship applications are open to college students who are majoring in architecture, engineering, or environmental engineering. Last year, we supported the STEM pipeline with over $40,000 in college scholarships. Join our scholarship opportunities, share our scholarship opportunities with a college student today, and help support their financial journey through college. We've extended the deadline to Monday, April 15th, so share these opportunities with a college student today. Would you like to reach a community of 7,000 architecture, engineering, construction, technology leaders? Join DC Post's annual sponsorship. We have an opportunity to leverage our networks and showcase your firm with visibility and international recognition you won't get anywhere else. Support the sponsorship as well as program sponsorship, like the First Friday series, as well as our regional leadership and mentoring program and individual events throughout the year. Check out all the benefits on sponsoring and support the mission of DC Post in your community today. And for more information on each of these deadlines and events, please visit our website or reach out to myself. I'm happy to talk to you more. We got 2 notable events from SAME National. If you'd like to add to your calendar, voting for the national directors is now open on the SAME.org website. Vote for your next society president, vice president, and board of directors now until April 15th. And join SAME community at the Joint Engineering Training Conference and Expo, JETC, in Orlando, May 14th through 16th. We're looking forward to attending, and registration is open. And Marie and I will be there alongside Ed Chamberlain and Anna Ehrman from the VA, presenting on a panel session on building your company differentiators to win big. Earn PDHs, network, and celebrate the achievements our AEC industry has at the awards program and military ball. So join us. So definitely come join us in May. Don't forget, if you'd like to volunteer at the conference, you can get a free registration to attend. So learn more at the SAME JET website. And lastly, be sure to visit our website at same.org/DC post to mark your calendar for all coming events and programs, as well as mark your calendar for any national events as well. So June 12th, we have our June joint conference with ACEC and the CMMA on major construction programs, opportunities, trends, and strategies. This one-day conference features updates and programs from Amtrak, NAVFAC, and OBO. Early sponsorship is available. You can get early recognition as soon as the event registration opens up at the end of April. And we've rescheduled our climate resiliency and electrical infrastructure program to meet in July. And we are planning a fun summer networking event at our favorite speakeasy in DC. So look for registration for these upcoming events. Thank you again for attending our first Friday webinar series with Nicole and Sarah from Polero Mazda, and for providing excellent content today. So please look on for document delivery with the subject line, for slides, your PDH certificate, an opt-in list of participants today, and we will post this recording later on this month. So have a great weekend, everybody, and we look forward to seeing you at the next SAME event. Thank you.